Okay, next section deals with conflicts of interest. And as you probably have already found out by looking in the beginning, the number one most heavily tested topic in professional responsibility is conflicts of interest. You are almost guaranteed to get one of these on your bar, or actually the main conflict, and then there'll probably be specific conflicts that you're going to deal with it. So this is conflicts of interest in general, and these are all specific conflicts that relate to it. So it's all part of the same general area of law, but there's the general conflict and there's specific conflict. Okay, so let's take a look at it. The lawyer owes each client a duty of loyalty and must act in the client's best interests. So it must keep the client's best interest in mind. The lawyer may not represent a client if the representation of one client will be directly adverse to the other. So essentially, a lawyer cannot represent a husband and a wife in a divorce proceeding because their interests are totally against each other. So that's when they're directly adverse, or similarly, the lawyer may not represent a client if there's a significant risk that the representation will be materially limited by the lawyer's responsibilities to another client, a former client, and we'll talk about former clients here in a second, a third person, or by the lawyer's own interests. So if you have a client that's going to sue your corporation, and turns out you're a 70% owner, you own a 70% stock in that corporation, and the client wants to sue the corporation for a substantial amount, do you see that there's a significant risk that the representation will be materially limited by the lawyer's responsibilities and by his own personal interests? Because as a lawyer, I don't want you to sue that company and win, because that money is going to essentially be coming out of my pocket because I'm a 70% shareholder. That's what second part of this rule means. So it's not directly adverse, but there's a substantial risk. So the critical question is the likelihood that a different interest will arise with and interfere with the lawyer's judgment? Could you imagine in that example that I gave you, if I'm a 70% owner, 70% ownership interest in a company, and the client wants to sue that company for a substantial amount of money, can you see how I'm probably not going to give the client the best of my ability to represent him? So the representation will be materially limited by my interest, my personal and financial interest to the company. Okay, but despite the existence of a conflict, a lawyer may represent a client if the lawyer reasonably believes that she will be able to provide competent and diligent representation to each affected client, and each client gives informed consent confirmed in writing. So informed written consent, essentially. It's very similar to that. So even though you have, that's what's called the reasonable lawyer standard. So even though I know that there's a significant risk that the representation might be materially limited by by other interests, like a duty to a former client or another client, or my own personal interest or a third person, I can still represent the client if I reasonably believe that I can provide competent and diligent representation. Now, that example I gave you with the 70% ownership interest, unlikely to happen. So the representation is prohibited if, based on all the facts and circumstances, a reasonable lawyer would conclude that that competent and diligent representation cannot be provided. In other words, a disinterested lawyer would advise the client not to consent because the conflict is unconsentable. So the rule in California is essentially the same. The only slight difference is that California only have to provide written disclosure to the client. You can send the client an email if the lawyer has a personal relationship with someone on the other side. So let's say that I'm representing a criminal defendant, and he hires me to, in a DUI proceeding. Turns out my wife's the prosecutor. So is there a risk that the representation might be materially limited? Under that situation, I think it's consentable, because even though you're going up against your wife in a DUI battle, you still want to win, and you're still going to give the client everything they can. So that would be consentable. And California would have to provide written disclosure to the client and say to the client, hey, my wife is the prosecutor. In fact, you might even get a better deal that way. My wife is the prosecutor, and is that okay? You have to send the client an email and the client no. Under the ABA, of course, you have to get the client's confirmed informed consent in writing, and you should explain to the client why that's going to be a significant factor, why it's not going to inhibit the relationship or prevent me from providing competent representation. Okay. So also, don't forget that the representation will certainly be inadequate if one client asks the other not to disclose to the other client confidential information relating to common representation. So let's just say that I represent two gentlemen that want to start a partnership, and they want to start whatever kind of partnership they want to represent. First of all, you should be, by representing them both, they're not directly adverse, their actual interests are aligned at that point. But down the road, if the partnership fails, they're probably going to sue each other, and if they end up suing each other, the partnership agreement that I wrote for them is going to control. So in that situation, there might be some risk that the representation will be materially limited by my obligations to the one partner and to the other partner. I may or may not be able to represent them effectively. Odds are you probably could, but, and this is what this part down here, the duty of confidentiality in regard to conflicts. If one of the partners tells me something and says, hey, you can't disclose it to the other partner, that is where the conflict really gets an issue. Because now I have a duty of confidentiality to this client, but this client, who's the other partner, I can't give him full and fair representation because I have to protect this one's confidences, but I can't tell this one everything necessary to be informed about the representation. So in that case, the lawyer must withdraw because the conflict in that situation is unconsentable because I have one person who wants me to keep it quiet, and now I can't tell the other client necessary information that they need to know, and that's why it becomes that. So if one client asks the lawyer not to disclose to the other relevant information relating to the representation, the competency will be inadequate. You're not going to be able to do it because the lawyer has an equal duty of loyalty. I just explained all that. Okay, serving on a board of directors, also under conflicts of interest. A lawyer may serve on the board of directors for an organization that he represents. Just make sure the responsibilities and the roles don't conflict. So example, a lawyer may be called upon to advise the corporation in matters that involve a wrongful act of one of the directors. Don't forget, in corporations, directors set compensation for other directors. So if I'm supposed to be, I have to advise the corporation, maybe you got to get rid of this director, it might be my friend. That's where the conflict would come in when you serve on a board of directors of the organization that you actually represented as its attorney. So, as I said, the duty of loyalty, conflicts of interest and duty of loyalty, it's the same thing. Because if there's a conflict, then you can't be loyal. And it appears on almost every single PR essay, and I do mean almost every single one. It's about 98% chance you're going to see it. I mean, it gets so frequently tested that I almost got done listing it. Okay, now former clients. A lawyer who has formally represented a client may not represent another person in a substantially related matter if that person's interests are materially adverse to the interests of the foreign client. So essentially, if I've represented somebody, I can't use anything that I've learned from that representation with the former client to help the new client if it's going to be a conflict. So also I may not reveal the former client's confidences. So the lawyer may not use any confidential information learned during the representation to the disadvantage of the former client. So if I know this former client did one thing and I want to tell the new person, can't do that. So even after termination, a lawyer still owes a former client the duty of confidentiality and the duty of loyalty. So I still have to be loyal to the former client's interest even though the representation is over. So that's what duties of former clients is all about. Okay, using information to the client's disadvantage. So a lawyer may not use any confidential information or any information for that matter learned during the representation to the disadvantage of the client. And generally this rule applies when confidential information is used to benefit the lawyer or a third party. Let's say that I represent a corporation and they're about to go, like not a corporation, but maybe just some small business is about to go public. And then we know that there's going to be a tender offer, or there's going to be a stock offering, or there's going to be an IPO, and you know the company's stock is going to go up. I can't use that information to purchase stock or to tell my wife or my brother or my best friend to purchase stock, because essentially what you're doing is you're cutting off money from the people who are going to own the stock for, that are within the know, the insiders of the corporation. You're using it to the disadvantage of the client. Also, if I know that a developer is going to build some property nearby and he's planning to buy up all the houses, and the houses are going to go for way over market value because he needs to buy all of them in order to develop that land, I can't purchase one of the properties or tell my friend to purchase one of the properties so that we can end up selling the property to the developer at a much higher price. So you can't use any information to the disadvantage of the client. Okay, business transactions, or when you take an ownership interest with the client. So a lawyer may enter into a business transaction with the client or acquire an ownership interest that is adverse to the client if the terms are fair and reasonable and are fully disclosed in writing to the client, and they have to be in language that is understandable by the client, so it has to be understood by the client. Also, the client is advised to seek the advice of independent counsel, and the client must give informed consent in a signed writing. So this rule applies when the lawyer accepts an interest in the client's business. So let's say they take an ownership interest in the client's business, obtains a lien on real property owned by the client. So let's say the client wants to pay me, and allows me, says, well, I can't pay your legal fees, I'm cash poor, so go ahead and take a lien out my property. Well, in that case, again, the terms have to be fair and reasonable in a manner that's fully understood to the client. It must be in writing, and you must tell the client, hey, you might want to seek the advice of independent counsel so they can look over this to make sure you're not getting ripped off. So an interest in the client's business, obtains a lien on real property owned by the client, makes a loan to the client, or accepts property as payment. So if one of the clients is going to pay me with like a Picasso, you have to make sure that, again, it's fair and reasonable and the terms are fully disclosed, and seek independent counsel. Now, the rule does not apply to standard commercial transactions. So if you're a lawyer and one of your clients is like a merchant that deals in, let's say they're a merchant in paper goods, and you want to strike a deal with them to buy paper goods, in that situation, that's not the situation where it has to be in writing. So the rule does not apply to standard commercial transactions between the lawyer and the client for products or services that the client generally markets to other. In such transaction, the lawyer has no advantage in dealing with the client, and the restrictions are unnecessary and impractical. And if you look at that example that's on page 15, currently on page 15, the pages might change, but if you look at that example there, that explains it really well. It's the best way that I can explain it to you so that you see it. It was tested once in 2006, and it was part of contracts where the lawyer entered into an agreement with the client, who was also a manufacturer, to sell widgets or to sell some item. And in that case, the lawyer had the client was not at a disadvantage in dealing with the lawyer. Okay, that's business transactions. Again, we already went through all the elements of that. Okay, the next topic is financial assistance to a client. That means paying litigation expenses and loaning the client money. So a lawyer may not provide financial assistance to a client. So you can't give the client money, you can't pay the client for testifying, et cetera, et cetera. But what you can do is you may advance the costs and expenses of litigation. That's a contingency fee agreement. That happens all the time. That's totally fine. And if you're representing a poor person, indigent clients, that usually happens when the client has a case that you're trying to prevent some type of discrimination or harassment, and you say, look, I got it, and the poor person, the indigent client, never has to pay you back. That's when you're allowed to provide financial assistance to a client. And that's only to pay the costs and expenses of litigation. That's it. You may not agree to pay a client's living expenses. And count about loaning clients money, so you may not pay living expenses, only litigation expenses and cases for poor people. In California, it's okay to loan a client money, not in the ABA, but under California. You may lend the client money, provided you've already been hired and retained. So that means after the lawyer's hire, he can loan money to the client, except the client has to have a written promise to pay the money back. Now, that also brings up a business transaction, because now you're loaning the client money. Again, you can't have really high interest rates, like charge the client some like 18% interest, because again, terms have to be fair and reasonable, fully disclosed, so on and so forth. So those kind of overlap with each other. Okay, next topic, sex with a client. California is now in line with the ABA rules, and that is a lawyer may not have sex with a client unless, of course, you have a prior relationship. I mean, if you're representing your wife, you obviously can continue not having sex with her, because if you're married, you're probably not having sex. A sexual relationship can unfairly exploit the client's trust to the disadvantage of the client. So when you have a client, you can't engage in a sexual relationship with that client, and because you don't want to exploit the client's trust and the confidences in the lawyer, and it gives the lawyer too much power and advantage. Now, keep in mind that even if you have had a prior sexual relationship, let's say that I'm representing my long-term girlfriend of 2 years, there might come a situation where we end up breaking up during the case. And in that case, you have to decide whether there might be a potential conflict that my personal interests will interfere with competent representation. Remember we talked about now my interests with my girlfriend when I represent her, they're not directly adverse, but is there a significant risk that the representation might be materially limited by my own personal interests? What if we break up? Do you think I'm still going to be able to provide competent and diligent representationship to somebody who just did something like that we hate each other now? I mean, that's when you have to think about, okay, that's a potential conflict. A reasonable lawyer would say probably it's okay, but if things get really bad, you might have to actually withdraw. So anytime you have a sexual relationship, you can't have sex with a client, but if you have a prior relationship, think about whether or not there's going to be a duty of competence issue or a possible conflict of interest down the road with your own personal interests. That does appear. That has showed up on the bar before. Okay. Acquiring an ownership interest. So a lawyer shall not acquire an ownership interest in the subject matter of the litigation, except that a lawyer may acquire a lien that's authorized by law. And there's what's called the family law real attorney's lien. Let me explain how that works. In a divorce proceeding, a lawyer may acquire a lien on the client's interest in the community real property, the family home, to pay the lawyer's legal fees. So let's say husband and wife own a house jointly, and the wife wants to get divorced and hires me as her family attorney in the divorce proceeding. Now, I can't take a contingency fee on that based on securing the divorce or the amount of property or alimony that I get her. What I can do, actually, is if she has no money to pay me, I can get a lien. It's called a family law attorney's real property lien. I can get a lien on the family home. Let's say she owns it in tenants in common, so she owns 50% of the home. And I can get that lien that allows me to take out my legal fees when that property sells. So that's when you can acquire an ownership, because don't forget, I'm acquiring an ownership interest in the house because now I got a lien on it. I own a small percentage of that house, the amount of my legal fees. So I'm acquiring an ownership interest in the subject matter, but the lien's authorized by law, and also you can always get a contingency fee agreement. We already know that. And again, terms must be fair and reasonable too. So I can't take her entire interest in the house. If it's $1 million house, my legal fees are only gonna be like 40, 50,000. Okay. So that's what's going on with acquiring an ownership interest. Agreements prospectively limiting malpractice liability. Can't do it. So a lawyer may not enter into an agreement prospectively limiting, that means in the future, limiting the lawyer's liability for malpractice, unless the client is independently represented in making the agreement. The reason for the rule is that most clients are unable to evaluate the desirability of making such an agreement before a dispute has arisen. I mean, how are they supposed to know, wait, you totally messed up my case, you totally made me lose a winnable case, and I can't sue you now? They're not going to understand that in the beginning until they actually get screwed over in the end. So in short, a lawyer cannot obtain advance consent to incompetent representation. All right, conflicts for former government lawyers. It's only been tested once. I mean, so here's how it works. I'm just going to go through it quickly. A lawyer may not represent a client in connection with the matter in which the lawyer participated personally and substantially while working for the government, unless, of course, the government gives informed written consent. So when a lawyer is disqualified from the representation, now this rule has to do with screening for government lawyers moving into private practice. So if you're a prosecutor moving into, like now, a lot of prosecutors end up doing criminal defense and they become criminal defense attorneys, and let's say that they ended up prosecuting the client and now they're going to represent the client, that's not going to fly. So if you're working for a firm, so when the lawyer is disqualified from the representation, no lawyer in the firm may undertake the representation unless the disqualified lawyer is screened off, shares in no part of the fee, and written notice is given to the government. Again, this rule permits screening for government lawyers moving into private practice, but this applies at firms. But just in general, if you're a prosecutor and you move into private practice, you may not represent a client in connection with the matter in which the lawyer participated personally or substantially. So if I was working for the government and I was doing this whole big drug bust and I was doing all this, the intel undercover to make sure that we got certain members of this gang, and then I move into private practice while this is going on, I can't represent one of the gang members. That's essentially what that means, conflicts for former government lawyers. Okay, safekeeping property and client trust accounts. A lawyer must hold a client's property separate from the lawyer's own property. Additionally, the lawyer must place client funds in a trust account separate from the lawyer's own property, so there's no commingling of funds. Thus, all funds received by the lawyer for the benefit of client must be deposited in the client trust account. This includes any unearned legal fees, not true retainers, unearned legal fees that have been paid in advance by the client. Generally, they sometimes will take like a retainer, like you'll say, okay, I'll take $10,000, charge you $300 an hour. And the fees may only be withdrawn as they are earned. So let's say that I work 10 hours, I can withdraw $3,000, but I must keep that $7,000 in the client trust account separate from my own property. So a lawyer is also required to return to the client any money the client is entitled to receive. So I have to return, let's say I get fired after doing 10 hours of work at $300 an hour, I can keep $3,000, I must return the $7,000. However, a lawyer is not required to return any funds the lawyer reasonably believed are owed. So let's just say there's a dispute about $5,000. I earned $5,000, there's a dispute about $5,000, and so I can keep the earned fees. If there's no dispute about the earned fees, I can keep the $5,000, but the unearned fee, the disputed funds must be kept in the client trust account until the dispute is resolved. So it must stay there neutral until it's resolved. And any undisputed amount must be promptly returned to the client. So if any of the money in there isn't money that I earned and I don't have a dispute with it, I must give that back to the client. So when there's an undisputed amount, I must promptly return any of the undisputed money to the client. So again, if the client paid me $10,000 and I've made $3,000, but the client thinks I only made $2,000, we have a dispute about $1,000. The $2,000 I can keep, the $1,000 stays in the client trust account, and the other $7,000 must go back to the client because that is not a disputed amount, it's an unearned fee, and now the client wants the money back, I have to send that money back. But that $1,000 that's in dispute, I can keep that in the client trust account separate from my own property until like a neutral party, like an arbitrator, can resolve the dispute. Okay, final thing we have here is withdrawal. Believe it or not, withdrawal is actually not that heavily tested. Most people think it is, but it's really not. A lawyer must withdraw if the representation will result in a violation of the ethical rules, if the client demands that the lawyer engage in conduct that is illegal, or if the lawyer is fired. Now that part of the rule deals with mandatory withdrawal. But a lawyer is not obligated to withdraw simply because the client suggests that the lawyer engage in illegal conduct or violate a rule. Oftentimes the client may make the suggestion in the hope that the lawyer will not be constrained by a professional obligation. Because don't forget, the client doesn't know that the attorney has ethical duties to follow. The client, unfortunately, most people, or some people, believe that lawyers are just going to do anything unethical and lie, and that's completely further from the truth, at least according to the ethical rules and the way that I've seen the practice conducted. Of course, the lawyer may withdraw if the withdrawal can be accomplished without a material adverse effect on the client. The client has used the lawyer's services to commit a crime or a fraud. If the client and the lawyer have a fundamental disagreement because the lawyer considers action by the client repugnant. That usually happens to do with when you're taking maybe a criminal case where you find out that your client, who is arrested for maybe theft, turns out to be, just when you have a fundamental disagreement with the client. Or the representation will be unreasonable financial burden on the lawyer. That means the client's not paying the fees. And again, upon termination, the lawyer must return all of the client's files and must take steps to protect their interest. Okay, so that's a wrap. That's what we have here for Section C, conflicts of interest in the client-lawyer relationship, the most heavily tested topic in PR, conflicts of interest.